Hello, once again, good morning, and warm welcome to our first webinar in the series exploring accountability for international crimes committed in Ukraine. This webinar series is part of our project titled Countering Impunity for War Crimes and Crimes Against Humanity in Ukraine, Visegrad Contribution, which is done in partnership with the National University of Kyiv, Mohil Academy, the Institute of Law Studies of the Polish Academy of Sciences, and the Faculty of Law of the Pavlichenko University in the Czech Republic, with the support of the Visegrad Fund. The project is mapping domestic criminal cases involving international crimes, and it aims to select allegations of international crimes warranting investigation by the Office of the Prosecutor of the International Criminal Court, by answering to what extent is Ukraine willing, able, and active in trying and prosecuting these criminal cases. My name is Rastislav Shutek, and in the Platform for Peace and Humanity, I'm leading this project. As mentioned, this is the first webinar in the series, which will be followed by a webinar about crimes committed during the occupation of Crimea, conflict in eastern Ukraine. A specific webinar will be dedicated to the downing of the MH17 flight and the role of the ICC in establishing accountability. And also one webinar will be dedicated to the role of foreign fighters in the conflict. Today, we will explore a chapter in relatively recent Ukrainian history, which resulted in unfortunate events in Ukraine that we are all aware of. That is the Maidan protests in late 2013 up to February 2014. Some time has obviously passed since then, and the crimes committed during the protests or Maidan Revolution, also known as the Revolution of Dignity, has been evaluated by the Office of the Prosecutor of the ICC in its 2015 report on preliminary activities. Where the office found insufficient evidence to demonstrate widespread or systematic attack against the civilian population within the definition of crimes against humanity. In January 2021, the European Court of Human Rights issued 5 judgments in favor of applicants, victims of human rights abuses during the protests, and found violations of the prohibition of torture, inhuman and degrading treatment, right to life, the right to liberty and security, among other rights. The court also found in this regard, and I cite, the absence to date of an independent and effective mechanism within Ukraine for the investigation of crimes committed by law enforcement officers and non-state agents, also known as Tytych. I'm happy that today we are joined by 3 excellent speakers, namely Oleksandr Matviychuk, who presently heads the human rights organization Center for Civil Liberties, and also coordinates the work of the initiative group Euromaidan SOS, an initiative group created in response to the brutal dispersal of a peaceful student rally in Kyiv in November 2013. Vitaliy, senior partner at Vitaliy and Partners law firm and founder of a non-profit lawyers association, Advocacy advisory panel, also known as the Heavenly Hundreds Lawyers, a group created to pursue a goal of an independent, objective, and comprehensive investigation of Euromaidan crimes and providing pro bono legal services to Euromaidan protesters and their families. And Oleksandr Pavlichenko, Executive Director of Ukrainian Helsinki Human Rights Union, Deputy Head of the Commission under the President of Ukraine on Pardons, member of the Legal Reform Commission under the President of Ukraine, and former Deputy Director of Kharkiv Human Rights Group. In the very same order of panelists, I will ask each panelist to finish within 15 minutes so we can open the floor to Q&A interaction. The public is also encouraged to leave questions in the Q&A box, and without further ado, I pass the floor to our first panelist, Olexandra Matviychuk. Please.
Hello, it's a huge honor for me to take part in this panel. I was a coordinator of civil initiative Euromaidan SOS during Maidan events. This initiative was created as a response of brutal crackdown of peaceful student demonstration on 30th of November 2013. And from that day, till all the 3 months, we work 24 hours a day and provide legal and other aid to persecuted protesters. We united several thousands of volunteers throughout the country. We united several hundreds of lawyers who work pro bono in order to provide legal assistance to persecuted protesters. And because we face with a systematic and widespread attack from our government to the peaceful protest, at the end of all this event, we have a database with 16,000 appeal for help, which we provided to national prosecutors bodies and to International Criminal Court. Euromaidan SOS, it was only one of from the many initiatives which created during Euromaidan events. Because Euromaidan, it was a self-organized movement and different groups, different people took responsibility for a different direction of work. As I told, Euromaidan SOS was responsible for law protection and documentation, and other initiatives were responsible for medical care, and we have a network of hidden hospital when it started very dangerous for beaten protesters to be in official hospital. Also, another initiatives were responsible for logistic and transfer. Other initiatives were responsible for cultural dimension, and they make slogans, banners, pictures. So they were different kinds of these initiatives, and according to statistic, 2 million people took part in Euromaidan protests like a direct participant throughout the country, and more than 5 million people took part in the protest like infrastructure of the protest. So Euromaidan SOS, it was one initiative which was support the protest and was a kind of infrastructure. As I told, we faced with widespread and systematic attack against civilian population, and this attack were coordinated from one center. It was deliberate policy. It was organized for one scheme. And during this attack, the official bodies closely cooperate with paramilitary groups, so-called Tytych, and implement this scheme in order to suppress the peaceful demonstration. They use different methods to do it, like they use legal mechanism, like searches, legal detentions, fabrication of administrative and criminal cases, interrogation, but also extrajudicial methods like killings, beatings, tortures, kidnappings, and others. And there is some illusion that when we speak about Euromaidan, we speak only about Kiev, but these attacks were widespread because Euromaidan protests and participants of this movement organized different events in different regions of Ukraine. So this attack have big geographical coverage and rather big scope of victims. In addition to these pictures, I just only mentioned that we have a special media coverage, which is controlled by government. We try to show all participants like extremists, like radicals, and also specific law conditions, because during this event, government and parliament try to limit the law possibility for freedom. And at the 16th of January, they adopted so-called dictatorship law and put all kinds of legal protest beyond the law frame. This law is violated the Ukrainian constitutional and international standards, but it's also show that everything which was done by government, it was a part of the complex strategy in order to suppress the peaceful demonstration. And that's why, based on the widespread nature and systematic character of this attack, we can say that it was a crime against humanity. When the Euromaidan finished and our former president Viktor Yanukovych escaped to Russia, the role of civil society in order to investigate this all crimes which were happened during Maidan still remains very high. The one group were responsible for providing law assistance, and later was appeared the so-called group of lawyers of Heavenly Hundred. The Heavenly Hundred, it's name of people who were killed during Euromaidan events, and they represent their relatives in court and investigation. And also different initiatives which provide civil oversight over the process of investigation. For example, our organization and our civil observation group Ozone provide court monitoring over some concrete cases and try to understand what's going on with investigation. Briefly speaking about the problems which we faced during the first year of investigation, I must to say that in 2014, we have no investigation at all. Because all these criminal procedures were investigated by different state bodies, by different people in the state bodies, and with no coordination, with no understanding that they have a organized nature and controlled from the center, and they have to be investigated like this. And that's why we lost 1 year. And after the pressure of human rights organizations, lawyers of Heavenly Hundreds and victims, it was created a special department in General Prosecutor Office, which has played the role of this single investigative center, but the head and people who work in this department faced with a lot of barriers, a lot of obstacles, sabotage from Minister of Foreign Affairs, from Security Service, problems with on the judicial level, as well as some problems from the head of General Prosecutor Office itself. That's why we have to say that the whole result of the investigation, which for current moment we have, is the result of efforts of lawyers of victims, the victims themselves, and some enthusiasm people who work in this official investigation and who have to even to confront with their heads and of these bodies. Unfortunately, the reforms which was made in Ukraine in the sphere of criminal justice don't use this situation and don't understand the particularities of the situation. And we had also a problem when all these cases has to be transferred from General Prosecutor to newly emerged State Bureau of Investigation. And there were a lot of problems also with it. And still the State Bureau of Investigation now take a lead in these cases, and my colleagues Vitaliy, Tytych, who represent a lot of victims in this process, will talk in more details about the level quality of these investigations. And parallel, since the 2014 human rights organization closely work with International Criminal Court, we were first who sent the official submissions according Maidan events to International Criminal Court, and try to present everything which we saw by our eyes on the language of documents, evidence, and legal theory. And as I understand about work with International Criminal Court, my colleague Oleksandr Pavlichenko will tell more. So I just only to show you that as during Euromaidan events, as well after Euromaidan events, The role of civil society in this process is very essential. And as we told, after Euromaidan, it's our intermediate victory because we only won the new task for ourselves, which we have to fulfill now. I will stop here and will be glad to answer to the question.
Thank you very much. We have one question that we can probably leave for the end once all the panelists take the floor. So at the moment, I will pass the floor to Vitaliy Tytych for his intervention, and then we will finish with Oleksandr Pavlichenko, and then we can answer the Q&As.
Good morning, everyone. Thank you for opportunity, organizer, especially Rostislav, to join this event and take opportunity to hear honorable speakers and tell something about helpful for this event. As I said, Oleksandra, I'm a lawyer, I represent victims of the crime in a criminal proceeding which conducting concerning these criminal cases. And I'm co-founder of attorney organization Advocacy Advisory Panel. It's an organization lawyer which support victims starting the 2030, and 7 years we take part in criminal proceeding in stage of investigation, state pre-trial investigation, and of course in particular trial. And I can try to help all with information from a particular case file of investigation, can describe the evidence which we gathering and brought to the court. Sorry for my English. Of course, my level of English doesn't respond to high level of this discussion. I hope that Oleksandra helped me in this process. She knows all. She supports us, lawyers group, since 2030, as she said. Of course, it's very strong and helpful support. Only support of civil society, particularly of Oleksandr organization, can all us achieve the results which we have now. Despite that problem with shortly described Oleksandra, which we have during all these 6 years, I'd like to stress it only support of civil society and interest of for these cases can support us as a lawyer and victims in this process, and I'd like to say it another one. Thank you to Rostislav. In this situation, we need to have opportunity to spread true information and discuss about these events, about the results of the investigation, of course, and discuss with our partners, foreign partners, because now we are faced with international campaign to destroy the facts, the creation of fakes and myths, incorrect assessments of the situation by international organization. It's very important to have chance, opportunity to explain represent the evidence, particular evidence, not our words, and particular evidence which we achieve, and spread this information. Of course, Oleksandr described the situation, and I'd like to only stress it, and very important moment in this, I will start. As Oleksandr said, all those who died during the protest were killed or received lethal injuries in January, February 24th. It's important information. Initially, protest and any action has not violence character. The crimes were committed by authority and pro-government so-called Tytych. It's important Tytych were under police control, and later authorities distribute firearms to Tytych. It's evidence from a particular case now in court trial, and it's important information for a reason of this event. Starting from that moment, peaceful protests occurred a more violent character as a result of unsatisfied violence by police, unlawful arrest, kidnapping of activities, torture, and law restricting civil liberties, as said Oleksandr. Such as authorities acted arbitrarily and intentionally used excessive violence. The excessive violence and unlawful arrests and became a part of government strategy. It's very important. It's established by the court, especially it's established by the court decision, not only Europe, not only national court, is established by the case of several cases in European Court of Human Rights, particular case Vorontsov against Ukraine, and European Court stated the government strategy to provoke violence from the side of protesters is very important moment. Almost all crimes related to the mass protests were out in a demonstrative and intentional manner. It's important. Numerous of journalists, media reporters, freelancers, protesters took photo and videos of crime, including murders. In this case, as a rule, videos and photos were taken openly, in some cases directly from the crime scene. All videos and photos were immediately posted on the internet, and so future audience were able to see this almost live. In this context, important indirect evidence includes the completely atypical behavior of law enforcement officer who committed crimes. They knew that they were being filmed, but did not interfere with the filming, even when committing the murders. It's very important for understanding what indeed happened during the mass protests. The investigation materials also contain the other evidence to suggest that all crimes episodes, from the brutal beating of the students in November 30, 2013 to the mass killing of protesters on February 20, were part of signal criminal conspiracy carried out according to organizer general plan in order to radicalize society as much as possible. Accordingly, the publication of videos of crime in the media and the internet was the most effective way to committing this crime. Important circumstance which established by the court, not only investigation, I mean court trial, particular court trial, it's the Russian interference. The investigation established that during the winter, groups of employees of FSB and Russian Ministry of Interior Affairs came to Kiev 3 times and have a meeting with the high-level Ukrainian authorities, including President Yanukovych, former president, and of course, it's involving in this process must be established by the another evidence. Now this evidence have the investigator and prosecutor, but it doesn't represent in court, and I have no power to open its public, but I stress it that Russian interference there was and there are now even in process of investigation. Another important circumstance, important for international understanding, international level understanding and evaluation by the international society what happened in Ukraine, is facts of creation new extremist organization. During the autumn 2030, a number of extremist organizations were created. Most successful, it's so-called right sector and white ham. They usually use the national slogan and symbols, and these organizations are associated with provocation and motivated attacks on law enforcement. But this way, they were involved in process to radicalize this peaceful protest. To what I'd like to stress it, sorry, the organizers aimed to provoke mass protests by committing a series of successive terrorist attacks, organizing this action in interest of Russian Federation, as I said earlier. Their intention was a trigger to international conflict in order to create a pretext for annexion and or occupation at the so-called casus belli, and legitimization of aggression in international level. In my opinion, according to international humanitarian law, Russia committed a crime of aggression, and Russia committed aggression waging war in unconventional way, committing war crimes, deliberately gross violation of the laws and customs of war, immolation of civilians, premeditated murder of civilians, torture. Russia moved to an active stage preparation for aggression after Putin's coming to power, investing heavily in creating a network of its agents in Ukrainian law enforcement agents and courts. For this purpose, the FSB used KGB malls to recruit during the Soviet era. Given this circumstance, according to criminal theory, criminal offenses in the main episodes of Maidan are the set of crimes where terrorist attacks are the main crime, and identification of bodily harm, torture, abdication, unlawful deprivation, liberty, and murder of protesters and law enforcement officers, condition of or matters of preparation, the main crime. now we have, I should describe the results of investigation due to the problem which we have and which Oleksandr described shortly, such as sabotage of investigation by the top manager of Ministry of Internal Affairs and Security Service, particularly the Ministry of Internal Affairs, former minister, like Arsen Avakov. He is personally responsible for discrediting the investigation, such as the number of senior police officers charged with committing crimes against protesters continue to hold, even now, position as the Interior Minister. Avakov's guarantees of immunity of the criminals and it's destroyed. Avakov action destroyed particular all investigation process according to this officer. Of course, the second problem is continual obstruction by the leadership of Prosecutor General Officer during the whole period of this year, 6 years. Another it's a problem. It's a legislative house. Verkhovna Rada failure to provide the investigation and trial process with necessary registration. Another problem: excessive delays in forensics examination. And other. But however, even under such conditions, Special Investigation Department headed Matlichuk. It's as Olexandra told, it's a special unit which was created by our support and managed to investigate the main criminal episodes and gather sufficient evidence to prove in court the guilt of the person involved in the crime. The best results of the investigation were achieved in the Cape proceeding, the case into the terrorist attack on February 20 in Institutska 3. It's the main case, as I said, and is in this case established very important evidence, important not only for this particular criminal proceeding, established evidence which describe, which open for all interested what happened indeed during this protest, during the Maidan protest. This case was sent to trial in 2015, and as I said, now is the final, with the main problem, but I hope in the final stage. Evidence which is established by this trial, it's involvement of the organization of the terrorist attack by ex-president Viktor Yanukovych and senior law enforcement officer. The main problem now, biggest problem at this stage for establishment of justice is blatant sabotage by judges in Maidan cases. It's like Oleksandr says, the lengthy and indelicate consideration by the court of these trials. trials in Maidan-related cases are deliberately delayed due to unsatisfactory returns to indictments, recusal judgments, judges' changes of jurisdiction, and another procedural reason. But it's a big problem. It's happened because sometimes trials, court trials conducted by the judge, which involving is the same crimes, and even that crimes which was have indictments from investigator in relation to this events of Maidan crimes. Of course, victims and families of victims do not have opportunity to exercise their right to justice in proper way. But we hope, we try to finish some cases. We hope now in Ukraine started so-called reform of judiciary. And we hope it's ensure the process of trial. Thank you, sir.
Thank you very much, Vitaliy. Thank you also for bridging the protest with the follow-up events, especially the annexation of Crimea, that will be surely discussed in the following webinar. Now we can proceed with the intervention by Oleksandr Pavlichenko, please.
Hello. I will speak about the procedure under the International Criminal Court and the role of civil society in the submission to this international institution. As Oleksandra said, from the beginning of the event, civil society organizations not only participated in the support of the protesters, but in the actions and in the collection of the facts of brutal violations of human rights. And it was not very clear, first of all, when we were in December, in January, in February of respectively 2013 or 2014, what will be the result and what we will be do with the recorded evidences and the facts that were filmed, taped, written, interviewed, and so on. Apropos, I may tell that some of facts and some of documents disappeared, and the perpetrators tried to organize the elimination and not accept, not allowed to receive more information from the organs, from the state bodies that were linked to the might be considered as violators or participants in the violations. And for example, the municipalities, some all the institutions of law protection structures like CBU, like police or Office of General Prosecutor, and so on. And it creates really the difficulties in collecting the whole mosaic picture what was as a fact, and to have the full picture and to prepare the well-grounded submission to the ICC. And all three of us, Vitaliy, Oleksandra, me, myself, we participated, as I remember, since the summer of 2014 in the preparation of the submission to the International Criminal Court. And what is important, this work was not only hidden, but we, as a result, we published the publication, Sasha, Lesa, do you remember this Price of Freedom? Цена свободы. So the submission to ICC is published in this, it's almost 25% of the submission, but with more concrete materials sent to the Hague. The document was accepted apropos, and I will briefly explain what was happened later. It was very new experience for all of us how to prepare the submission to such international structure and what we may expect. And after the first submission, the concrete questions were sent from The Hague with the request to bring more concrete details and explain especially the concerns of the bureau that considered this submission, about the widespread character and about the systematic characters of the violations occurred during Maidan time. I may refer on the report issued on 12th November of 2015. It's very full version of consideration of submission mentioned before, and explanation on the reasons and the motives why the ICC expect that probably Ukrainian side may add something to this submission to accept and to have the decision that the case will be considered under the Article 7.1 and 0.2 of the code of the Rome Statute. I just remind that Ukraine has not ratified the Rome Statute till now, but on 17th of April in 2014, Ukraine sent the first declaration with the recognition of the jurisdiction of criminal court, and second was sent in 2015 in October, as I remember, especially on the event. First was sent especially on the event occurred in Maidan time. We speak about roughly 20 days, and ICC concretize that we have roughly 12 days that might be considered, let's say, concentrated with the violations that might be considered under the Article 7 of the Rome Statute, meaning that the killings, the non-balanced use of the and non-proportional use of the force use of the weapon against civic population, and this riot button and non-selected punishment and even use of firearms constitute the brutal violation that might raise the level of crimes against humanity. And at the preliminary examination, yes, it was stressed that the proposed materials and facts might considered under the angle that they constitute such a level of the crime that might be considered under the Article 7. And then when the Bureau followed the rules of the Article 17, the availability criteria, and we have the whole picture in this report presented in November of 2015, and references to this report were made in the last declaration of the General Prosecutor in November of last year. I just refer that she said that still a European international court, as Mrs. Bensouda Fatou expressed on 12th November during the presentation of her report, it was annual report as well, still consider the possibility to reconsider all the conditions and facts that are related to the Maidan case in the submission done by the sent by the Ukraine. But Ukraine, I just remind, stopped or has no, let's say, progress in the support of the process in consideration of the case inside of the ICC. And yes, it's true, we have no more facts, we have no more proofs, and as my colleague said, we have not, first of all, political will to investigate properly on a national level and as well on international level, except we may not influence on the consideration of the cases in the European Court of Human Rights. The violations occurred in Maidan time. And two big objections that were expressed by the Bureau of the General Prosecutor in her office, that the registered violations might be considered under the angle of the Article 7 of the statute, but Ukraine has to prove they widespread and systematic character, because as for the time being was mentioned by the ICC, the events took place mainly in concentrated place, in very concentrated time. As I said, it was roughly 12 days in 2-3 days in November, beginning December, then 2 days in December, I mean 11 December, 4 or 5 days in January, and 3 let's say it was the most tragic days, and 3 days in February. So, and mainly all events occurred in Kyiv, and the concentration of events was near Maidan Nezalezhnosti, and well, other reasons and motives were expressed by the as you may see in this annual report on the under the position of chapter dedicated to Ukraine. I may even tell you the paragraphs, but you may find yourself. And finally, as the final conclusion that was expressed by the prosecutor of the ICC, that in the light of the facts, well, office of the prosecutor might reconsider and to return to the consideration of this case when it will receive more information, especially on the proof of the widespread character and systematic character of the attacks that was mentioned at the let's say the politics of the current regime in the time of Yanukovych presidency, and it's a pity that first of all we have not sufficient means and sufficient sources for find and gather and prepare such evidences, and the situation now is let's say frozen, and as I see the situation, we have not too much perspectives that it might be reconsidered, because no new facts will appear. Yes, we have the problems with the prosecution on national level, and it might be one of the reasons that when we have not proper prosecution on national level, we may also address to the international structures, but it is also the issue of the European Court of Human Rights, Article 6, I just remind you, and I see more perspectives with this procedure, and one more concern that was expressed in the raised by you questions about the possibility of prosecution on national level. We have to take into account the limitation period, so it's time for the suiting of the perpetrators that is different for different type of crimes. And I just remind you that in Ukrainian legislation, we have not properly fixed the criminal prosecution for the crimes against humanity. Until now, we have this only single article 438 in the criminal code that has not procedural support, and it is not used at all in the case of Maidan cases. And all the cases were and are considered only under the ordinary criminal legislation and with the respectively limits for different types of crimes. And I just remind you that the highest time for the heavy crimes is the 10 years. So we are on the 7.5 years terms and 2.5 years, and then the time for suit will expire. For the other crimes, it's even the less, 3 and 5 years. So we even lost the time for several prosecutions due to non-proper attitude from the law enforcement structures, from the judicial system, and as Vitaliy said, yes, I agree with him that the lack, it's not only the lack of the political will. I think that, to my opinion, it was a kind of compromise between the powers, let's say former, and then the power that was successor of the previous power, that it will be not proper prosecution, so it was some kind of hidden pardon, and we see just results of this process, and we try to do our best, and we work fairly on the protection of the victims, and Vitaliy and Lesya are the, let's say, fighter on this visible front for the rights of the victims, and no proper, let's say, political and state position except on memorization of the event, but without proper results with the prosecutions and let's say punishment of perpetrators. I will stop here and ready to answer your questions. Thank you.
Thank you very much, Oleksandr. I'll start with one question, getting back to Vitaliy's intervention. He mentioned that there is a court procedure on a national level with evidence demonstrating the control between the law enforcement authorities and Tytushkis, non-state agents. I was wondering if this new evidence can be resubmitted to the Office of the Prosecutor for its reconsideration, especially given that there is a new ICC prosecutor.
Yeah.
That's probably a question for all three, if you can answer.
If you mean, okay.
Well, I may, well, yes, it might be sent to the office of the prosecutor, but well, it will not change the situation hardly with the opinion to reconsider, because it is not proof. It's not proof that still the violations became the character widespread and systematic. So we may just, let's say, it will not change the critical mass of the evidences that the Office of the Prosecutor will take the decision to reconsider. That's why, yes, it is possible and we may do it, but it's not reasonable when we just calculate the time, resources, and so on. It's just the work for no results. Sorry.
Yes, please.
As I understand the question, question was, can any new evidence from particular court trial to support, to accelerate consideration, change opinion, previous opinion of ICC, and accelerate consideration? I think no. I agree with Oleksandr. In my opinion, court has enough evidence of widespread and systematic. Another evidence, additional evidence, can change situation at all with this. And I think I try to stress it. As I understand, I can't explain it properly, and I will try another. For reconsideration in that court, in my opinion, personal, we should bring new evidence, almost new evidence, which it change angle, as I said, Oleksandr, for consideration, not for consider that crime on Maidan, not only like crime against humanity. In my opinion, as I said, it's another crime which is jurisdiction of criminal court. It's a crime, first of all, it's crime of aggression, Article 8, as I remember. And of course, it's that crime evidence, as I try to describe, it's a terrorist attack on civilian population organized by the aim of Russian Federation, part of aggression. It's another qualification as committing war crimes. And if we change this angle and will bring this evidence which we achieve in particular cases to criminal court, in my opinion, we can change angle of consideration and accelerate this process. Despite the result of this consideration, it's very important in this situation, in this case, which we have now, in my opinion. Sorry for my English.
I will add to my colleague and try also to answer the question which we have in our Q&A box. And in order to do it, I want to draw your attention that according to their policy, International Criminal Court are focused on so-called big fish. So the responsibility for ordinary executors of the crimes still remains the obligation of Ukraine. And in order to do it, I mean, to prosecute people who committed crimes against humanity on the national level as well, we have to solve the problem of criminal court in Ukraine, because in criminal court there is no even terms such crimes against humanity. And if we speak about war crimes, they are not appropriate with the norms of international criminal and international humanitarian law. And 5 years ago, human rights organization, Human Rights Agenda Platform, started to solve this problem. We developed a draft law, registered this draft law in Parliament. In this Parliament, it was registered under the number 2689, and finally we achieved, and it was not easy for us to achieve that Parliament adopted this draft law. And now this draft, which harmonize criminal court with international humanitarian and international criminal law, which provide a legal instrument for Ukrainian national prosecutor bodies and judicial system to prosecute people who committed crimes against humanity and war crimes, are waiting still in office of president. The term, constitutional term for signing this draft law vanish, and we don't know about what will be with this draft law. And we hope that this month Ukraine will host a Crimean platform, and one of the main request Ukraine from authorities to international partner is to help Ukraine to prosecute perpetrators. And we really hope that Ukraine by themselves do something in order to realize this request. And we wait from President of Ukraine to sign this draft law 2689 and to establish a new form in criminal court, like crimes against humanity, and develop the war crimes in it. Thank you.
One more question from the public. Were cases transferred to the State Bureau of Investigation deliberately to obstruct justice, or was it simply a coincidence? It's probably a question again for all three of the panelists.
Well, it's not simple question because we have to describe, and I think that it's no time and place to describe here whole development on national level, how the, let's say, the Maidan cases were considered by. But well, yes, according to the legislation, it's exactly State Bureau for Investigation that should investigate such type of crimes. The problem is that this structure is newly created, and the composition of this structure is also, let's say, not so simple, and we may not tell that it's proper instrument to investigate especially these cases. And the former structure was destroyed, or let's say the case was took from the group of prosecutors who were dedicated to these cases, Mr. Serhiy Hrobotyuk, for example, and his team. It's you should know the national context, and it's as I said, it's not it's not necessary to describe here. Yes, when we just briefly may tell that it's probably it's a part of the process that I've mentioned before, not to have a very successful story from this investigation, but have all procedural, let's say, fulfilled requirements, that it was according the law, but with the such result. And when we have, for example, the challenge, we have to answer the question: shall we have the process or the result with the positive results? Here we have the process, but not the expectations on the positive result. Thanks.
I can agree with my colleagues when we speak about problems with investigation during this year, which was done artificially. We can name a lot of them, but this concrete legislation, I think it was only a part of a more huge reform. And the author of this reform, they don't the specific of Maidan crimes, because what was the problem when all these Maidan cases has to be transferred from General Prosecutor Office to State Bureau of Investigation? We speak about at least 4,500 criminal procedures. It's thousands of documents. It's thousands of videos. It's thousands of evidence which was gathered during these years. And new people in State Bureau of Investigation, which have to suddenly take all these materials, evidence, and videos, need to spend at least 1 year in order to read it, to understand it. And this was a possible pause in investigation. And that's why we understood this problem in the early stage, and together human rights organization, lawyers of Heavenly Hundred, victims of this event, send a lot of appeals to Parliament, to General Prosecutor Office. Please look into this problem, because after 2 years of moratorium, we will face with a problem of losing institutional memory in this investigation. But as this time appeared, and all cases started to be transferred, and only after a hunger protest of some of lawyers of Heavenly Hundreds, Parliament made very slightly change to legislation, and only some people from previous department can be hired by State Investigative Bureau in order to continue their work and to share their knowledge with the new colleagues.
I might agree with my colleague, but I stressed another factors. All this situation, colleague described as a result of objective circumstance, such as legislative changes or another. I'd like to stress it that destroyed department, Matviychuk department, which lead in conducting investigation during 5 years, was intentionally by the Ukrainian authorities, intentionally, of course, for a reason to sabotage that investigation. And now we have a result of this, of course, and but we don't forget about how it, who and how it conducted.
Thank you very much. And let's finish with one final question from the public. And that's what are the guarantees or perspective that the perpetrators for these crimes will be tried? Or in other words, will there be impunity for these crimes?
Good question.
Yeah, it's Vitaliy, you may start.
I'm sure we work for this, and early or later it happened. It's a process, historical process and objective process. We have a problem which we try to describe as investigation and punishment. This perpetrators establishing and punishment by the court, but I hope social and political changes in our country, first of all, can change this situation, and we achieve that result which you mean. We work for this.
Maybe I will continue. I'm optimistic about results of investigation. The problem is that I have no vision of deadlines, and will I be able by myself to see the result of this investigation? I'm totally agree with Vitaliy that this is historical investigation, and if our generation will lost the opportunity to provide results, we know the other examples from history when authorities returned to such kind important investigation and provide them properly and obtained the results which society, which truth, with which relatives of victims needed. But in order to do it by our generation, I think that there has to be a complex strategy. I mean, said earlier about law legislation, also we need to increase capacity of State Bureau of Investigation. But in order to do it, the Ukrainian authorities as well as Ukrainian society has established this like a goal. Because we need to think about the context. After Maidan, we have a war with Russia. The half territory of Ukraine were occupied, Crimea and Donbass. The war crimes is still going on, even now, which we held the seminars. The legally arrested people are tortured in the secret prison in isolation. So the priorities are changed for sometimes for objective reason. And I totally believe that we need to return the Maidan investigation into priorities, because and to the Ukrainian authorities' attention, civil society attention, and international community attention. If we set it like a priority goal, we can find a way how to obtain result. For example, we had a good work of advisory panel of Council of Europe. They finished their work, but they can continue their work and provide parallel investigation or oversight of Council of Europe, how Ukraine fulfills the obligation to fight with impunity. We can find hundreds of other methods how to push the investigation. From my point of view, the main problem is this with the priority, because all good things in Ukraine are made like this: civil society kicks, international community kicks, a non-repaired, non-reformed, non-repaired state machine slowly started moving in the right direction. So first, we need to understand that this is not only matter of justice, it's not only matter of truth, it's also matter of like recognition what happened during these events. The fascist state переворот, as Russians said, Russian propaganda said, or it was peaceful protest against authoritarian corrupt government, and only the proper investigation, not political declaration, but law court hearings, which based on proper evidence can make a dot in the sentence.
So Oleksandra said everything. So I may just add that from my perspectives, the work on the collection and the preparation of submission to the international structures like ICC was not in vain, because of just one concrete example. Next Monday, on 9th of August, the trial will take place in Kyiv with the considering the issue of sanction to Mr. Yanukovych in the context of this Maidan case investigation. So it's just one concrete answer to your concrete question, how we consider the perspectives for prosecution. So, this process that we are in, I mean, the process of the preparation of submission to ICC, the investigations and prosecutions on national level, and let's say kicking from different sides, from international society, from civil society to the law enforcement structures. Well, it creates the let's say the non-stopped action with the perspectives that we have concrete marks and notes on the facts, what was done. For example, when we look into this report of the prosecutor of the ICC, we have concrete description that yes, it were the crimes that arise of the level of the crimes against humanity, but it was not enough to start the procedure for consideration from the ICC side. but still we have this appreciation, and we have the procedure that starts to push the national authorities to bring new evidences, and it was the case, and it was the process in the last several years that Mr. Horbatyuk department worked on that, and whole Procuratura dealt with that, and it's the process that and the result even on the current stage that is satisfactory and bring us the expectation that the evil will be punished. And now the evil has its name, and it's also important result and conclusion, I think, and appreciation of the work realized by us. Thank you.
Thank you very much. And that wraps up the Q&A session. I thank all of our panelists for a wonderful presentation, engaging Q&A. I thank all the attendees for joining us today. And I wish all of us a nice Friday and a good weekend ahead. Thank you again. Bye-bye.